All right, everybody. Long time no see. Let me introduce you to Bill Purtell. Bill is a lawyer with Lerner, Sampson & Rothfuss, and he's been doing foreclosure law for 16 years. So when the economic crisis hit in 2008, Bill was positioned to really do a lot of very significant work. And he's one of the nation's experts in foreclosures. He's been doing it for 16 years. So primarily, he works on the side of banks, but not only on the side of banks. He's also representing consumers. But some of the biggest banks are his clients, and so he trains them in how to do foreclosures as well as going to court himself. So we're really lucky that he happens to be here so close to us, and really thank you so much for being here. I've been telling them about you, and his presentation is great. By the end of today, you should understand foreclosures. Okay, so thank you for being here.
Thanks for having me here, everybody. I'm always glad to be here. I do warn people I am a litigator, so I will talk the entire 75 minutes. If you want to get a word in edgewise, raise your hand, yell out, do whatever. I'm pretty informal. There's no red, green, yellow lights for me like at the Court of Appeals, so I do not know when to stop. I've made some notes, but hopefully I will keep it within the presentation. So, as Liz said, I do foreclosure law. This is all I do. It's my 100% of my practice. I do a little bit of both sides. I work for the Legal Aid Society of Cincinnati, and I do eviction defense, foreclosure defense. It's kind of hard for me to do a lot of foreclosure defense because of the whole conflict of interest thing. But there's a lot of small banks, mechanics liens, and other folks out there that I can always practice my skills on, and that's always I find highly amusing when I get to put on my other hat. So I'm going to give you the lender's perspective simply because the lenders are the ones who most often go through this. At the height of the foreclosure wave, when we're writing the wave, our office would file 60,000 cases a year. It would affect a homeowner once. So that's why I'm saying as a 60,000 to 1 ratio, the lender's perspective is generally the one you will encounter in most textbooks. They've got the most to learn from that. That being said, I will try to pepper the discussion with things from the defense bar or rights that homeowners do have that interact with this, because that's going to be the great dance of foreclosure. It's going to be a question of what are the rights of a secured creditor against real estate versus what are the rights of the homeowner who obviously has pledged their property for the repayment of the debt. So with that, my first slide is just Black's Law Dictionary. And to date myself, it's the 6th edition of the Black's Law Dictionary. I think they're up to 9th right now. But either way, what is a foreclosure? To shut out the power, to destroy an equity of redemption. Okay, what's an equity of redemption? It's the right to save the property from foreclosure. Kind of seems technical, but really, the way this used to be envisioned is there's 3 basic types of foreclosure. A strict foreclosure is you make your payments, and when you don't, the bank immediately owns your house. As soon as you default, bam, by law, you don't own your property anymore. A statutory foreclosure, which most commonly goes by the name as non-judicial foreclosure, is a statutory process, rule-based in these various states, to notify a homeowner of their default, to sell their property, and to otherwise complete the foreclosure. No access to the court. A homeowner would have to go to court to seek an injunction against a statutory or non-judicial foreclosure. And then the last type, which is the type I primarily deal with because it's the most complex, is a judicial foreclosure. In all 50 states, you can file a lawsuit in equity. It's considered an equitable action to foreclose a property. The judge will oversee the case. The case will be like any other civil lawsuit. In fact, I've got a flow chart for it, a little deeper in the slides. And that's, you know, a full-blown lawsuit. It's a case in equity, so homeowners will often demand a jury trial for this foreclosure. You don't get jury trials in matters of equity. So I'm going to mix in a lot of civil procedure with the foreclosures because statutory process is okay. I can kind of follow those and you follow that. But as soon as you get into judicial, the rules of civil procedure are real important, along with the rules of real estate, which is what I would like to focus on here, but I'm also going to get into secure transactions, possibly a little uniform commercial code. For all those people who never wanted to take UCC, I'm sorry. That's what I specialized in law school. It was all good. I worked for some small companies before law school that would bounce my paycheck, so I thought, you know, I'm going to go to law school and I'm going to work for banks, because banks never go out of business. Worked for about the first 6 years of my career, and then, oh well. But then I learned real estate. Like Scarlett O'Hara at the end of Gone with the Wind, real estate never goes away. So if bank client A was foreclosing the property and went out of business, bank client B would end up buying the loan because the real estate and the mortgage never went anywhere. So real estate is still a good, long-term goal for what I think is employment security. So with that, I have a chart on what are the judicial and non-judicial states. The majority of the nation is non-judicial. To be in a judicial state, it's about 26 or about 22 states out of the 50 do judicial foreclosures. The rest, mostly west of the Mississippi, are non-judicial states. West of the Mississippi, especially with hotbeds like Texas and Georgia, you get a lot of really strong banking lobbies. You have a long history of, land loans and farm loans compared to the Northeast, the first settled countries, and other older states that embrace more the judicial model. It's just a difference in factor. Who's ever seen the movie 310 to Yuma? Either the original or the Russell Crowe version. That's a foreclosure movie. It's about a foreclosure movie in Texas where, 100 years ago, they would burn down your barn in order to force a default on your loan so they can immediately do a strict foreclosure and take your house. Or if you're the hero of the movie, you take a job as a mercenary just so you can pay your mortgage. See? There's all sorts of interesting movies about foreclosure. The 310 to Yuma is a cowboy movie, but I still find it amusing as a foreclosure attorney that the whole thing is based off of a guy who really needed to pay his mortgage. That kind of heroic effort to throw criminals in jail and take federal mercenary money just to keep the family farm. So that's why it's a good thing that we have lots of rules about foreclosures, and that sometimes foreclosures are slow or do have statutory provisions that do protect homeowners to prevent, unscrupulous lenders, which in that case was the neighbor in the movie, from immediately taking the house. So it's very rare that you will ever see a strict foreclosure, an immediate, boom, your house is gone upon default kind of thing. That still exists in modified ways through the use of land contracts. I'm not going into land contracts for today, but when you do land contract law, that's a whole another bag of worms. I'll give you a hint. Kentucky treats them like mortgages. Ohio treats them sometimes as mortgages, sometimes not. I just want to bring that up in case anybody tries to play stump chump on me at the end. And I am using an old chart from the MBA that was from 2009. I did make some changes to Massachusetts and Iowa, so if you ever look up this map, it'll look different on the internet because I'm just doctoring my old notes. Things change. Because who makes the rules? The state legislatures make the rules. They're the ones that determine whether they're going to be judicial states, non-judicial states, quasi-judicial states, that would be North Carolina, or anything in between. So really, all politics are local. All foreclosures are real estate law. Real estate law is obviously a very local thing. Now, I will touch on the federal laws that impact foreclosures. Blessedly, they're few and far between because I hate federal rules affecting foreclosures because it's a nationwide rule. It's hard to craft one rule that works in all 50 states with every iteration of each state's foreclosure laws. So if you go to California, they have something called the Homeowners Bill of Rights, which is a very lengthy set of laws that was passed a few years ago to give extra civil procedure and due process protections to homeowners in a foreclosure. California is mostly a non-judicial state. You get to Texas. Texas is a non-judicial state, usually pretty bank-friendly, but they love home equity. If you own your house, Texas doesn't want you to unown your house, so they've got very strict rules on what happens if you have a home equity line of credit. You went out and bought a car using your HELOC loan. Texas doesn't want you to lose your house because you used your house as a line of credit. A credit card is generally an unsecured loan. If you don't pay your credit cards, they might garnish you. They might, call you up 60 times a day, but they usually don't take your house. So in Texas, they have special restrictions on HELOC loans. Those got lightened up a little bit in 2017, but once again, that's unique in the nation. Georgia, Super Tuesday auctions. Georgia is one of the fastest states in the whole nation. On the first Tuesday of every month, they auction every single property in the whole state in foreclosure. Not every property, but everyone in foreclosure goes to auction on the same day, on a Tuesday in Georgia. There could be 20 people standing on the courthouse steps. Everybody's yelling off their own auction. It's chaos. But, you know, as long as you file your statutory notices about maybe 10 to 14 days in advance, you can get on the Super Tuesday calendar, and if you miss it, you wait until next month. But compared to the 9 to 12 month calendar I'll show you in my judicial states, I find Georgia crazy fast, crazy fast. The problem is most of my lender clients love Georgia and they love Texas because it's crazy fast. So anything that's not them gets me in trouble, and it's nothing of my making. You go to Michigan, you can complete a foreclosure and then wait 12 months to see if the homeowner exercises that equity of redemption we talked about before. Can the homeowner get their house back? You can't evict them during this 12 months. You can't do anything. So basically you foreclosed, you did a foreclosure sale, and then you're sitting on the property for a year doing nothing. So it's kind of odd that Michigan is a non-judicial kind of quick foreclosure that has extended redemption rights. Pennsylvania has extensive pre-foreclosure notifications. They have, and we'll get into it a little bit later, some rules that say you must notify the homeowner in this way, at this time, by this method, to inform them of this saving their house program. And if you don't do any of that, 9 months later down the road, the homeowner can set aside your entire foreclosure. So unique things happen in every state. The strange thing about my states, well, what's not strange is we're judicial states. All foreclosures are judicial. Only the sales are controlled by statute. We've got no special rules on foreclosures whatsoever. When it comes to our clients, they're always asking me about legislative updates. That's one of the things I'm in charge of at the firm, is I have to monitor all the legislation and update my clients on it. And they always say, Bill, what are the special rules for pre-notices? None. What are your special rules for auctions? Really not none. What are your special rules for anything? We just don't have it. It's a very plain vanilla state, which is why it's good to kind of go through an Ohio or Kentucky judicial foreclosure process. This gives you the basic outline. If you go practice in any other state in the nation after law school, you can always pick up the local flavor of what's going to happen, but our states are pretty easy. That being said, our states have judges. The judges control judicial foreclosure processes. We have 88 counties in Ohio. We have 120 counties in Kentucky, so I have 208 masters telling me at any one point what I should and shouldn't be doing in their courtroom. So while I tell the clients we have no laws about foreclosures, there's lots of idiosyncrasies. I will not get into the judges' idiosyncrasies. I'll give you a hint. Cleveland's crazy. Louisville's crazy. The rest of the state's pretty normal. But, that's the Cincinnati guy in me. I'm always going to say Cleveland's doing something wrong. And I don't like that. So I probably just alienated half the class. I'm sorry. I shouldn't let my football politics come in. Go back. The problem, and this is completely random trivia, our bishop in northern Kentucky is a Steelers fan. So we have issues with that. So what I'm going to do is I'm going to divide this presentation into 3 distinct sections. Pre-foreclosure considerations, foreclosure litigation, because I'm going to be talking about the judicial process, and then the foreclosure sales process. So a lot of lenders chop it up into these buckets as well, and each bucket is handled by a different team at my clients. So the folks that handle the pre-foreclosure compliance will then be different than the folks who are handling the foreclosure litigation, which is different than foreclosure sale. I'll try to explain some of the nuances of the industry, but I know that not everyone is going to care, except it may affect how a homeowner works through the system and what rights are available to them, whether those rights are granted by contract, by statute, or just by common agreement with the lender. So one of the things in pre-foreclosure is trying to stop it from getting to the foreclosure stage. There are some mortgage contracts that have a provision that say your due date is the 1st of the month. You have a grace period till the 5th of the month to make the payment without a penalty, but the loan contract says it's still due the 1st of the month. So by the 2nd of the month, sure, you can pay without a penalty, but you're still in default. In some of the older mortgages, they're not really around too much nowadays, some of the older mortgages, and especially commercial mortgages, because commercial foreclosures work just the same as residential foreclosures. There's no difference in the law except for a couple nuances. And if you miss a payment and you are 5 days behind, your lender on day 6 or even day 2 of the default can immediately run to court and file the foreclosure action. Boom. One missed payment by 1 day, you're in foreclosure, you can seek judicial relief. Now, there's a lot of protections written into the standard mortgage templates, once negotiated by consumer interest groups, federal governmental agencies like Fannie Mae and Freddie Mac, the lending industry. So the standard mortgage has a certain pace to it, one of which is the Consumer Finance Protection Bureau, the CFPB. When it came into existence, mortgage lenders, or actually any of the lending industry, was like a piñata, and the CFPB took a baseball bat and started whacking the piñata till we cried foul and candy came out. So there's a lot of foreclosure protections that exist now by federal regulation that never existed before. One of which is, after 30 days, you must, before the 45th day of the default, start calling and contacting by written letters and by telephone a homeowner saying, hey, you missed a mortgage payment. This is bad. Let's work this out before it gets further down the line. So you have automatic loss mitigation requirements. Now, when it comes to loss mitigation, I don't know if anyone's taken their class in remedies, but obviously you're trying to remedy a contractual breach before damages get worse. But when it comes to loss mitigation, homeowners miss the fact that we're mitigating the bank's loss. We're not mitigating the homeowner's loss, because the homeowner could stand to lose their house. That's obviously bad. But when the homeowner doesn't make a payment, it's the bank who's out money, not the homeowner. So when homeowners talk about loss mitigation being tilted towards the bank, as a banking attorney, I say, well, yes, that's whose loss we're mitigating, and then I get in trouble for that. But they're talking about things like a forbearance agreement. That literally is just, we're not going to foreclose, we're going to buy time. Forbearance agreements don't work out anything. They don't cure anything. It just says, if you do X, Y, or Z, maybe make a partial payment, or maybe just, they agree just for time's sake, see if the homeowner can maybe get a new job if they lost their job, see if they can get an inheritance, see if they can maybe move out of the property or sell the house privately. But a forbearance agreement just forbears on moving forward. Now, a repayment plan, obviously, that's a good one. 18 years ago, that was considered the norm. Everybody wanted a repayment plan. You'd catch up an extra month and a half payment when you got behind at Christmas time, maybe. But through this financial default, one of the big issues was employment. When you aren't employed, you don't have income to make a payment and a half. You have problems making the first payment. So repayment plans aren't as popular anymore, but they're starting to come back. As the economy picks up and people have better employment, lenders will work out repayment plans to catch up the loan before it goes further into default, which is wonderful. Now, I never see these because they never get to my office. That's great. A private short sale. I'm going to sell the house. I'm going to give the bank the proceeds of the house. If I own more equity than the bank is owed, great. I pay off the bank and, put $5,000 in my pocket. That's great. Once again, if you can get out from underneath the mortgage, or if you can refinance, that works. A lot of times in a short sale, it's called a short sale because if you owe $100,000 on your house, but you can sell your house for $95,000, that's a $5,000 shortfall. Most lenders will still approve that and say, okay, we'll just take the loss. It's going to cost too much to go through foreclosure anyways. That, once again, is a great way to resolve it before it gets into the court system. Loan modifications are the big thing. They never really occurred until about 2008, 2009, and then they are now the #1 way to cure a default is repackage the loan itself. The problem is if you're $4,000 behind on your payments, they've now rolled that $4,000 back into your loan. You now owe more money than you began with, but at least on a month-by-month basis, you can restore an affordable monthly payment without having to catch up the amount of money you're already behind. So I like loan modifications. I settle a whole lot of cases. A loan reinstatement is, let's say you're behind 3 payments. Okay, here's your 3 payments. I'm caught up. That used to happen. It always happens in the spring. Why does it happen in the spring most often? Tax refunds. I love tax refund season. Once again, less work for me, more homeowners keep their houses, everybody wins. And that's just a bulk reinstatement. One of the things we're going to talk about is hiring attorneys is expensive, the cost of litigation is expensive, the cost of going through foreclosure is expensive, and most mortgage contracts once again, add that onto the amount you're already behind. So if you could pay $2,000 to catch up your loan today, but by next month when I file the foreclosure, that might jump to $4,000. Not because you owe another payment, but there's now $2,000 worth of fees and costs added to your account. So by the time it gets to foreclosure, reinstatement becomes a lot more financially difficult, which is why most people look at loan modifications. And then the end is the deed in lieu of foreclosure. We talked about strict foreclosure before, just give the deed to the bank and walk away. That's basically what a deed in lieu of foreclosure is, but it's a voluntary process. The only issue is a lot of homeowners would love to do that, especially if the property's underwater. Just say, hey, I'm not going to pay you off. Why go through the muck? Here's the keys. I'm gone. Problem is, as we learn in property, in order to accept title to property, you have to accept title. It's just there. You can't just deed something to somebody who doesn't want it. That's not a valid transfer. A bunch of homeowners do that all the time. In Ohio, it's a one-party deed state. Only one party signs the deed. You record it. It's assumed that the grantee has accepted title. But I just had a new case come in that got set up this morning where the homeowner decided to get rid of their, crappy real estate empire in Cleveland and just give it to the lender, and when the lender didn't want it. And it's got code violations, it's about to be torn down, it's got tons of tax liens, and the lender didn't want to touch it, so the lender hired me saying, Bill, I don't want to own this. I never agreed to own this. Get it out of my name. So now I have to file a lawsuit to undo that. Kentucky is a two-party deed state. One party signs for the granting of the property, but by law, both parties have to sign as to what consideration was paid. I don't know why, it's just an odd thing like that. So if you don't have the second party, the grantee, sign off on your deed in Kentucky, your deed never gets recorded. So, fake deeds in lieu of foreclosure don't happen as often as Kentucky as they do in Ohio. Why wouldn't a lender want to take a deed in lieu of foreclosure? Like I said before, maybe the condition of the property is such that the lender is going to lose money on it, or there's other liens. When you do a private transfer of title, you don't eliminate liens against the property. If I can tell you, I've got a mortgage on my house. If I just gave it to my sister, it would still have a mortgage on it. If I didn't pay off the loan and I just deed property to people, your liens don't go away. Nothing is satisfied. In a foreclosure action, though, what you're asking the court to do, which we'll get into a little bit later, is marshal all the liens, gather them, and use the power of the court to knock those liens off the title so that the title at the end of the foreclosure is clean as snow and has no more liens or encumbrances. So if I've only got one mortgage on my house, if I decide to give my house back up to my lender, they'll do a title report. They'll see they're the only lien on title. If I gave them title, they would have a clear title. They might actually take that deed in lieu from me, at which point, hey, once again, everybody's resolved their differences. The lender forgives the debt against the property, kind of like a strict foreclosure, but the voluntary. So that is the basic setup of what's going to happen before it gets into the process. So one of the things that we deal with is that there is always a loan component to these mortgages. A mortgage is a security instrument. All it is a secondary obligation that comes into play when the primary obligation, the agreement to pay back money, is breached. So if you have a standard 30-year mortgage, you have 360 installments, one payment a month for 30 years, and there's no acceleration until something occurs. Simply missing a payment does not cause acceleration of the loan. If I miss one payment, the other 359 payments don't immediately fall on me like a ton of bricks. Under the standard Fannie Mae Freddie Mac mortgage template, the one used by most lenders, and it's the government-approved template, you have to send a notice by contract 30 days ahead of accelerating the loan that says, dear borrower, you missed a payment. You have to catch up this payment, or else on day 31, I now have the contractual right to make you pay off the entire $100,000 balance. So this month you owe me $800. Next month you'll owe me $100,000. Please pay me the $800 so I don't have to accelerate the loan. So once again, that's a contractual term for reinstatement. If a lender does not send the contractual notices, you have a contractual defense. Hey, your lender, you can't ask for all the money because you didn't follow the contract. The contract is the private law between the parties that will be upheld by the court. There's also federal regulations. If you have an FHA insured mortgage, the federal government has an interest in not bailing out lenders for bad loans. So they require the lenders to take extra steps. I forgot to put the code site. It's 24 CFR 203.604. You can Google it if you need to. That your lender has to meet face-to-face with you. They have to sit down and offer you a chance to work something out at your kitchen table. Kind of freaky, but it's in the regulations. Once again, the goal is to work out the default before it goes through the foreclosure process, because on an FHA loan, guess what? My lender clients are going to dump the property on HUD. The federal government will end up owning your house at the end of foreclosure, and the federal government doesn't want to own your house. So they have federal regulations requiring the lenders to take extra steps to prevent foreclosure, or else, once again, a homeowner, and this is a very winning defense, will complain to the judge, hey, this lender didn't follow these federal regulations. If you don't follow the federal regulations, that's a violation of the mortgage. You can't foreclose. Lots of case law out there in Ohio where those are the cases I lose on. I can't do much about it. They're federal regulations. My client didn't do what they were supposed to do. I'm cool. And then there's state statutes. Once again, I mentioned that Ohio and Kentucky don't have any, but there's some states that, like the California Homeowners Bill of Rights, has lots of processes. The Pennsylvania notices, I think it's called Act 84. I am not licensed in Pennsylvania, so I hear other Pennsylvania counsel complain about it loudly and often. But in Pennsylvania, it's a jurisdictional defense. The court has no power to hear the foreclosure if the statutory prerequisites were not met. Any court that hears a case without jurisdiction, back to your constitutional law, here we go, has a void action. Void actions under the rules of civil procedure can be challenged at any time. Could be a year later, and you say, oh, that foreclosure was void, I get my house back. And the lender says, uh-oh, res judicata, you had 6 months to appeal, you didn't appeal, it's permanent. And the borrower can say, no, it's not. It's a void judgment. Void judgment is always a voidable judgment is one that starts out bad but can be cured by the passage of time. But if it's jurisdictional, it was a bad foreclosure from the get-go and can be set aside at any time. That's why I'm really glad Ohio and Kentucky don't have jurisdictional bars to foreclosures, or very rarely do they. There was a lot of litigation that I'll talk about a bit later on what is the jurisdictional basis of a foreclosure. In Ohio, big litigation hit the Supreme Court and came out with a very boring answer. But those are the questions I ask myself because I want to only do good cases that are going to be permanent. And a homeowner is going to think the same thing. If I'm defending this case, what are the Achilles heels that I can attack to get out? Now, it does make the fees and costs of the default go away. If a homeowner defeats a foreclosure, that just defeats the enforcement of the security instrument. The question is still, do they have the money to pay back the debt? And can the lender tee up the second foreclosure action if the first one didn't work? So when you're thinking about it, when is it appropriate to go to foreclosure? These are the kind of business questions that ask. What kind of default exists? Was it a loss of employment, a temporary hardship, a divorce? My favorite was NASCAR addiction. The wife was so mad because during NASCAR season, the husband would go to all the tracks, buy the jackets, the little model cars, and it almost led to divorce, but they were still married. But the wife just went off on me for 10 minutes about her husband's NASCAR addiction, and then they finally caught up the loan and saved their house. But, you got to ask yourself, what's the reason? It's very odd. Death is cause of default. A lot of times the heirs don't even know mom and dad had a mortgage until 60 days later when they're going through the estate process, and by then, the lender's sending foreclosure notices. What are the recovery prospects? Once again, if you live in a $15,000 ramshackle house in the middle of inner city Covington, the lender may not foreclose because it's not worth their time. If you live in a $500,000 mansion and the loan balance is only $200,000, well, you're a big old sitting target. You've got the money to pay, or at least your house has the money to pay back the lender. And so you're going to jockey to say, what can I get at the end of the case? And then statute of limitations issues. I have a specific slide on that. Actually, the next one. The statute of limitations depends on which one you're going under. Since we're doing a judicial action, you have to ask yourself, is there a state bar or a defense, because statute of limitations are affirmative defenses, is there a defense the homeowner can raise that says you waited too long? Well, there's real estate statute of limitations, there's security interest statute of limitations, there's, just suing on the debt statute of limitations, and they all have different interplays based on different states. In Ohio, it's 6 years on a promissory note, the debt action. Kentucky, it's the same 6-year statute. In Florida, it's a 5-year statute. There's some case law in some states that say once you can't sue on the debt, the mortgage goes away too. Because what is the mortgage? The mortgage is there to enforce the debt. If you can't even enforce the debt, your mortgage is worthless. Poof, it's gone. Other states say, well, our real estate statute of limitations is 21 years. Adverse possession, all that good real estate jazz. And a mortgage is a real estate issue, so we're going to let foreclosures be under the real estate statute of limitations. I can tell you, I've never seen a lender blow the 21-year statute of limitations. I had one lender get to 19 years, and I asked them what they were doing. But I've never seen them blow the 21-year one. Kentucky's only 15. So you've got real estate ones, and then you got the back and forth with all sorts of variations. Florida was kind of the bellwether for this because after the foreclosure crisis and the banks melted down, there was an attorney meltdown in Florida. There were just some law firms, not our firm, thank God, that just got too big too fast and just cratered under the weight of all the work they were doing, and 50,000 foreclosures cratered with it, and the lenders didn't know who had their file or what lawyers to go to, plus they were getting hit by the, I'm trying to remember the exact name of it, the National Mortgage Settlement that a bunch of lenders did with the federal government that kind of put foreclosures on halt to begin with. So, they had a lot of loans that actually went more than 5 years before they finally got to the foreclosure stage. So the homeowner's living in the house the whole time, finally gets the foreclosure paperwork and says, hey, I defaulted 6 years ago. You missed your window. I get this $300,000 condo for free because not my fault you sat on it for so long. And of course, that was a complete loss for the lender. A statute of limitations is a complete bar to an action. So it went through back and forth on whether, okay, well, Mr. Purtell, you said this was an installment loan. There's 360 separate causes of action, so they missed their 14th payment due on the loan. That was, 6 years ago. What if we move this and sued for the 26th payment? Hey, that's within 5 years. We can chop up all these payments and accelerate based on the 26th payment being missed instead of the 14th payment being missed. And, some defense lawyers went, oh, that's cute. No. And some courts of appeals and judges went, I'm not letting you pick which of the installments you're accelerating. But it turned out that, that actually is the law in some states that, you may have to write off the missed payments, but the lender gets to choose what is the cause of acceleration. And in a 360 payment loan, a 30-year loan, there's 360 potential causes of action. So they allowed that. And then there was also some law that said, okay, what about the reinstatement provisions? The standard Fannie Mae, Freddie Mac residential mortgage gives that right to reinstate that I mentioned before, a right to pay back what the lender is owed to cure the default. A lot of lawyers successfully argue that there is no permanent acceleration of the loan until that right expires. Until then, if a homeowner has a right to stop the foreclosure at any time and to undo the acceleration, we haven't hit a permanent acceleration that actually starts the running of the statute of limitations under the Uniform Commercial Code. I thought that was a very clever argument. Some of the courts have fought that. Ohio and Kentucky have not weighed in on that debate yet, so I have plenty of litigation that I'm still doing myself. But we bring it up because a lot of courts were looking at the Florida Supreme Court to kind of give some guidance on the interplay between the Uniform Commercial Code, acceleration, statute of limitations. The Ohio Supreme Court did come out with that Deutsche Bank versus Holden case, which I hope there's no Supreme Court justices or clerks in here. I thought it was a complete goose egg of a case. I hated it. It was an oddball case that said, we've got this whole statute of limitations debate, but I'm not quite sure if it even applies. But they didn't explain why or why not it would apply. And so they never hit the nail on the head and kind of talked about bankruptcy law for some reason as, setting aside the statute of limitations. Okay, whatever. But there's now a current of case law that says as long as you're not suing personally on the loan, a bankruptcy discharge, or you just are past the statute of limitations, you can't sue personally on the loan, that you can still proceed in rem, on the old Latin in there, against the property and still do your foreclosure within Ohio's 21-year statute of limitations. You don't get a personal money judgment. If the house sells for less than the debt is worth, oh well, you write off the remainder, but hey, at least you can proceed. It's not a total loss to the lender. So there's still some debate going on in Ohio about the difference between an in personam action, you can sue them personally on the debt, and an in rem action, does that have a different statute of limitations? Like today, I had a case. It was a commercial property, post-foreclosure. The guarantor signed a $1 million loan. Property sold for $600,000, and they're shocked that I'm going after them for the missing $500,000 they didn't pay back. They're like, wait a minute, I went through foreclosure. I'm like, yeah, my client took a $500,000 loss. Do you have $500,000? Like, no. I'm like, okay, well, that's nice. I'm going to have to collect against you because in our states, a judicial foreclosure is both a money action and a foreclosure action combined into one. And we'll get into why a little bit later, but it's just something to look for. You don't always get off scot-free at the end of the foreclosure if there's a deficiency remaining. So because of that, there's a couple more, restrictions they put on foreclosures just to give homeowners enough time. Once again, this is a federal statute for residential mortgages. Commercial mortgages out the door. I mean, if you want to sue a company, way easier, much nicer to do. But for homeowners of residential property, by federal statute or regulation, you have to wait 120 days from the date of default. So if you miss a payment, you've got at least 4 months before you will ever see a foreclosure. Once again, the contract might say, I can, sue you in foreclosure the day after you default, or 30 days after I send this acceleration notice. Well, under federal law, nope, you're waiting for 120 days no matter what. You still should follow your HUD regulations, your contractual notices, your state notices. You can do all that work and then sit on it until day 120. And then on day 121, you can tee up the actual lawsuit, or in a non-judicial foreclosure, the first notice is required by statute. Whatever your state's process is, day 121, you can finally take on. So that's what's going to be hard, though, is there's this built-in honeymoon period, which is good if a homeowner is working on saving their house, applying to the lender for loss mitigation, trying to work through the protections. It's nice. But if someone moved out of the house on day one and never wants to see the house again, they're going to be 4 months in the hole and owe that much more money by the time the lender's allowed to start the foreclosure. So a little bit of a double-edged sword. Most borrowers are trying to save their house, so overall, it's a good thing. It just means by the time it gets to foreclosure, by the time you're 4 months behind, it's pretty hard to catch up. So with that, we're actually getting to foreclosure litigation. I'm going to break it down into obviously the complaint stage, service and motions, and then the foreclosure judgment itself. So how hard could it be? Well, the clients always ask me that because they're used to Super Tuesday in Georgia. So we came up with this flow chart, and I actually have this laminated. It's sitting on my desk. It's like a placemat for a kid mat. I should get one for all my kids. They're very nice. But this is a judicial flow chart with timelines built in. Hard to read from here, but I think your professor will make this available at the end. It's proprietary, so please don't give it to my competitors. But with that, that is how a judicial foreclosure runs. So what we're going to start with is identifying the necessary parties to foreclosure. There used to be no statutes about this. You could just foreclose and do a very crappy job, and that was your problem, not the court's problem. But the courts didn't. Yes.
Can I interrupt? Can you go back 2 slides?
Sure, 2 slides.
Okay, right here. Forward one.
This one?
No.
This one?
Here. Yeah. Okay.
Okay.
What's the referral can happen before 120 days? That's when you're just talking about.
Yeah, you can give it to your attorneys. You can send all the notices. Because a lot of people say, well, you can't foreclose me. How did you add these fees and costs to my account? Well, you're still in default. The rest of the world still runs forward. You just can't file the first legal action until day 120. So that gives people a false sense of security if they think they have that 120 days and nothing's happened. Because during this 120-day period, we get the referral, and we're getting the foreclosure ready. In 2007, Ohio finally passed a statute saying, hey, we're actually going to require by a title insurance guarantee that the litigation attorneys who are filing these foreclosures will actually do their job correctly. Because there was a bunch of crappy attorneys who would just file against the homeowner, not check for other liens, not check to see how to do a good foreclosure. I said before, you want to marshal all liens against the property, get them all named, get them all under the jurisdiction of the court, so that the court can order a sale of everybody's interests, and the buyer at sale then gets a clean title that no longer has any liens or other interest against it. Tax lien holders, you do a title search. I mean, in Kentucky, you still have the old title examination books. Thank God most of these counties are online. Then again, they do make some errors on the online records that aren't contained in the books, so you sometimes got to go back to the books anyways. But now we have statutes. I'm going to give you both the Ohio and Kentucky statutes. Probably not going to be on your final, but just to let you know, each state does have processes that are codified about this. And anything that's not codified usually has a common law counterpart to it. So there's a lot of case law in foreclosure that's set up the way things should be done. Eventually got codified, especially through the foreclosure crisis when a lot of states really kind of tightened up the regulations, because nobody likes a crappy foreclosure, nobody likes missed liens, nobody likes just passing the buck down and not at least curing some title defects while you're going through the process. So it's both an art and a science. You would like to think that title reviews are easy and simple, but then, you know, as my first partner told me at the firm, if monkeys could do your job, Bill, I would have hired monkeys. So with this, this is where title examinations are different depending on what state you're in, sometimes what county you're in or what city you're in. I know some, land examiners in Hamilton County and Cincinnati who, if they miss a lien, they're committing ritual suicide right there in the recorder's office because they have shamed their family for generations. I've got some title examiners that go, oh, I blew that $12,000 mortgage. Oh, well, I'm going to put in an insurance claim. I have one of those right now that I'm litigating. We're very mad at the examiner, but them's the breaks. It's terrible. And then there's the horrible time where the examiner found it, and I made the determination that that lien didn't attach to real estate. That's where my name's on the line. And that's hard because variant names. Ronald P. Smith is entitled. Ronald R. Smith has a judgment lien against him. Doesn't attach to the property directly. There's no legal description attached, but by common name, a creditor's judgment can attach against all property that the debtor owes. So sometimes I got to rule out names. Now, I also like to run skip traces and Social Security name checks just to make sure it's not my person, but that's a judgment call. Attachments to vested interests versus non-vested interests. What's your life estate? What's your remainder interest? What's your fee simple? What's your fee tail interest? What's your dower interest? Is it an inchoate or a coate dower interest? I'm trying to remember if it's Ohio or Kentucky. I think it's Kentucky currently. I could be wrong. And one of the two states has a bill pending in the legislature to abolish dower interest because they're tired of being one of the only 4 or 5 states in the nation that still have vested coate dower interest. Everybody else only calculates dower when a death occurs because until they die, you can get divorced, your spouse could predecease you. Dower doesn't even matter until somebody's dead and you're claiming against the will. So a lot of states got rid of it. Ohio and Kentucky still have them. We're one of the few states in the nation. So once again, you're asking, does that interest attach to that? If your borrower is dead and the property descends to their heirs and the heirs have a judgment lien against them, does that judgment lien through the heirs go to the title of the property? I don't know. I'm not going to cover all that. That's what you're going to learn in the rest of your real estate class. But either way, there's a lot of stuff that has to happen to get ready for it. And then does that violate any statutory prerequisites? This is for lien filing. There's certain rules on how you file liens where, if you file a mechanics lien beyond the statutory period for filing a mechanics lien, the mechanics lien is purely a creature of statute. If you're a day late and a buck short, your lien doesn't exist. And so I won't name you in the foreclosure, and then after the foreclosure, you'll come to me and say, I have a mechanics lien. I'll say, no, you didn't. And then you'll sue the lender, and then the lender will say, Bill, I'm getting sued by this mechanics lien holder. Are you a schmuck? I'm like, no, I'm not a schmuck. But it takes me 6 months of litigation until the judge agrees, okay, Bill, you're not a schmuck. That is an invalid lien. At which point they appeal, and it's sitting with the Kentucky Court of Appeals right now. So either way, you got to make a judgment call on a lot of these things. And sometimes it's easier just to name them in the foreclosure and have the judge wipe them away anyways, instead of trying to be cutesy about being right up front. Give you that's a practice hint there for free. So when you prepare the complaint, what you're going to be doing is drafting, a basic civil procedure complaint. Every case has a caption. It'll be the lender versus the homeowner or whoever your defendant is. It'll have your statement of facts. The statement of facts in a foreclosure are pretty easy. You had a note, you had a mortgage, you didn't pay, the end. They're so cookie cutter. I hate to say it's cookie cutter, but it really, really is. A lot of the litigation isn't on how you draft a complaint. Now, a commercial foreclosure, where there's a ton of contracts and a bunch of weirdness and receivership, that can get a little goofy. But your standard residential one, basically, count one, you owe me money. Count two, I knew you might welch on me eventually, so I made you sign a mortgage, so therefore sell your house. And give me a money judgment. We always ask for a money judgment because we can't. You can do anything in the complaint. Count three. By the way, Bob signed the mortgage, but his wife didn't sign the mortgage, so we have a dower interest that's out there. I need to foreclose the dower interest, but I may have to pay part of it. I may have to resolve a priority dispute. I may have to reform the legal description. We said it was lot 34 when your house is actually lot 35. Whoops, we have a mortgage on the neighbor's house. And the neighbor didn't sign the mortgage. Whoops. You can reform that. There's all sorts of things you can do when you go in front of the court to clean everything up. A friend of mine was a painter. He said, you know, painters do tons of drywall. I'm like, why? He's like, because the drywall guy is going to make a mistake, and I got to paint over it, so I got to fix all the crap, and I'm the last line of defense for the homeowner. So same thing in a judicial foreclosure. In a non-judicial foreclosure, if you have a problem with your mortgage, you stop. You have no way of curing it because in this non-judicial process, there's no provisions to cure problems. In judicial world, oh, I have to cure all sorts of stuff. Now, I have to have good cause. This is still Civil Rule 11. A lot of people like to bring up the Civil Rule 11 issues. They say, Bill, you had no basis to claim that. And then, of course, I pull out the sheet that the borrower signed 4 years ago saying you absolutely have cause to do that. That's just the way litigation works. But you always have to know what you're doing, make sure the defaults have happened, make sure your client has done its prerequisites. You got to make sure the jurisdiction and venue is correct, which for foreclosures is pretty daggone easy. It's real estate. Pick the county where the real estate is. If the real estate straddles the borderline, okay, then you can pick either county, but it's pretty simple. Now, you'll notice there's a federal venue statute in there. That's the Fair Debt Collection Practices Act. Under the Fair Debt Collection Practices Act, mean old boogeymen like me are not allowed to sue people on debts anywhere other than where the real estate is located. That was state law anyways, but I do violate federal law and can get sued for damages if I pick a venue other than the one where the property is. Why I would pick some other venue, I have no idea. Lis pendens is the next important concept. I file the foreclosure on day one, borrower deeds the property to his neighbor on day two, or, files that fake deed in lieu to the lender and says, oh, not my issue, I'm not in foreclosure anymore, I got rid of the property. Well, that happened after I filed foreclosure. What if the homeowner goes out and gets a $5,000 second mortgage loan and the second mortgage, put a lien on the house in the middle of a foreclosure? No sane person would ever do that. Occasionally happens by mistake. Do I need to constantly be stopping my foreclosure to update the new people that gained an interest? No. Lis pendens is the theory that the action stands as it is. We're going to just freeze time, and the title to the property as of the date that lis pendens attaches is all I need to worry about. Anybody who comes along and gains an interest in the property afterwards has constructive knowledge of my foreclosure. If they don't intervene into my foreclosure, I don't have to provide them notice. I don't have to include them. I don't have to do diddly squat. On the day lis pendens attaches, I'm good from that point forward. Now, filing the action in the clerk's office in Ohio creates lis pendens. You always check the clerk's records when you're doing real estate. You don't just look at land records, you also look at the clerk of court's records. In Kentucky, it's actually recorded in the land records. Go figure. So, a lot of times you'll forget to release your lis pendens in Kentucky. So a lot of examiners will find a lis pendens notice for an old foreclosure that ended 3 years ago. Remember, it's just a notice. If the actual court case is closed and dismissed, there is no lien against the property. Lis pendens is not a lien. It's a notice. It puts people on constructive notice to check something else, to check for the status of that case. And then, of course, the plaintiff must have standing. This is one of that jurisdictional issue. Can the court hear this foreclosure? And the Ohio Supreme Court, after it went up in the Schwartzwald case, said, you should probably hold that mortgage before you file foreclosure. You shouldn't file foreclosure first and then buy the loan the next day. And all of us attorneys went, wow, really? But, the problem was the lenders were recording the assignment of the mortgage after the foreclosure happened. They bought the loan 4 years ago. They had the assignment sitting in their file. They just never filed it of record because, that cost money, and they didn't want to spend money unless they had to. So we had all of these foreclosure cases where it looked like you filed foreclosure on day 1, and by day 30, you finally acquired an interest in the property, and the courts were not happy with that. They thought it was sloppy. The great case came out that you actually have to have an interest in the loan first. What it really was just poor legal work by the attorneys and not proving to the court that the lender had bought it 4 years ago. It had some variations of why we got caught by surprise on that, but that's all cleared up now. Everybody reports their interest in land before they file their foreclosure. Standing and jurisdictional issues are no longer the hot topic. The lenders got wise that for $14 you recorded your assignment of mortgage and avoid going to the Supreme Court. So as much as that was a hot topic and there's a ton of case law out there, it's pretty boring and non-existent as a defense of foreclosure nowadays. But it still pops up every so often. And it's something we have to prove. We have to prove the elements of our complaint. So you can always raise the defense of standing just to make the lender do a little extra work and sweat a little more. It's perfectly valid. Borrowers are allowed to demand that. Now, of course, one of my favorite slides, the service of the foreclosure. Obviously, we're all going to quote Pennoyer versus Neff at this time. Gibbs versus, was Gibbs versus United Mine Workers one of those? No, U.S. Shoe obviously comes to mind. Everybody loves their service stuff. This is real estate. I can tell you, we can skip half the service stuff that you normally learn. Not because service is bad, but because if we can't find people, if you, let's say, moved to Europe for 6 months back in the 1890s, well, no one could reach you anyways. The law developed back then that if you didn't leave somebody in charge of your property, someone who read the paper notices, somebody who would receive notices, that you basically being a bad landowner. So constructive service is a unique facet of real estate law that allows you to achieve service without actual notification of the homeowner. Now, of course, you have to try personal service first. Send them certified mail. Send the sheriff to their house. Hire a process server to tag them with the summons. I've used all those before. I used to be a process server when I was in law school. It's a fun job. I didn't realize how much I could have been shot. But, it's the beauty of youth. But anyways, constructive service is if all of those attempts fails and you can't find them or they're dodging service or they have a shotgun, you basically put a notice in the paper. Dear homeowner, you're being foreclosed. You've been served. And that's it. Boom, you've been served. It's constructive notice, and the homeowner can come to court later going, wait a minute, that's not service. And the court says, yeah, but our rules allow it. It is a procedural mechanism to make sure real estate is not frozen forever just because somebody absconded from their property or is dodging service. Now, constructive service is for real estate purposes. As I said before, you're suing personally on the debt. If you go with constructive service, that personal judgment on the debt is gone. You can still prove the debt and prove the amount of the debt, but you don't get to chase the homeowner for the money after the foreclosure ends. It becomes an in rem only action when you do constructive service. Now, there are still some people after you serve them who do not believe in the power or jurisdiction of the court, people who believe they're free sovereign citizens of various states. I have some of those nowadays. I have some of those. But from the court's perspective, if you serve them, the court believes it has power over that person. So then the court becomes your friend. And I love when people file the, you have no power over me. Yeah, you've just annoyed the judge, who does have power over you. Because the judge has power over the sheriff does have a gun. So that's how a lot of these things get resolved. So with that, any questions on service? That's Civil Procedure 101. There's nothing particularly special about foreclosures except for the constructive parts. So, like all civil procedure, you've got 20 days in Kentucky, 20 days in federal court, or 28 days in Ohio, so check your local civil rules, to file an answer. Once again, if you don't file an answer, you're deemed to be in default under the civil rules. You're deemed to have admitted all of the properly pled and supported allegations of the complaint. Pretty easy. Back in 2002, most of my cases, I want to say 90% of my cases were resolved on default judgment. I claim you've got a mortgage, you've got a loan, and you haven't been paid. The homeowner would get the paperwork and go, yep, I agree. not going to pay an attorney for this. I'm just going to move and buy another house, or I'm just going to sell my house because property was appreciating. They could sell their house, pay off the old loan, pocket some money, buy a new place. It was nice when property values go up. Nowadays, it doesn't happen much anymore. After the foreclosure crisis, people couldn't sell their houses or get out of the old loans easier, so it made sense for them to instead contest the foreclosure, buy time, try to do something. But default judgments still exist. If no one wants to defend the property, if it's rental property and the landlord owner just wants to let it go, you don't have to respond to the foreclosure complaint. If you're the second mortgage and there's no equity, why pay money to get nothing from the foreclosure? We default lien holders all the time. It still means your lien is wiped away. It still means the foreclosure will move forward. It just saves me the trouble of having to litigate against it. Versus obviously under Civil Rule 56, if a party files an answer, you're going to file for summary judgment. You're going to support it with an affidavit. You're going to support it with discovery. You're going to go through all those wonderful things your civil procedure professor will talk about. There is nothing unique about foreclosures when it comes to litigation. Same civil rules, same as a med mal case, same as a contract dispute, same as anything. The court's going to give you a pretrial schedule, a discovery schedule. One of the only quirks is that not every answer is created equal. The answer of a homeowner usually leads to summary judgment. Generally, the answer of a lien holder does not lead to summary judgment because the lien holders don't care. Their only answer was, or the only thing we sued them for in complaint, I said we sued the homeowner for money, we sued the homeowner for the mortgage. Everybody else is just a marshal. The prayer is, tell us you have a lien or be forever barred from asserting that lien. So when a second mortgage files an answer, you know what they say? Yeah, I got a lien. At which point they have given me all the relief I have prayed for in my complaint. There is no contest of facts. I know I'm first, they know they're second, and we move on. So you don't file summary judgment on answers that don't actually contest the litigation. Now, if they put in an affirmative defense, oh, by the way, I'm first, I got recorded 10 seconds before your mortgage. Whoops. Okay, at that point, whoever originated the loan was supposed to record the first and the second, and that doesn't always happen, and then you get into a priority dispute. That would be cause for summary judgment against other lien holders. But generally, summary judgment is for the borrowers. Now, mediation and arbitration are, once again, remedies you can elect. I'm going to start with arbitration. Never happens. Generally, the lender chose to file in the state court, so if a borrower countersues, it's too late. The lender's already picked the forum. The lender can't say, oh, we got to take this claim to arbitration because it's cheaper. Now, usually the homeowners say, I sued you first. You would have wanted to get out of court to go to arbitration, but since you chose the state court, we're going to stay in state court. And, the lenders don't have much choice because you kind of always have to go to court in a judicial foreclosure. So arbitration generally doesn't happen much when the borrower countersues against the lender. We're all going to litigate it in the same case. Mediation is far more often, doesn't happen as much anymore. There's a one-sentence mediation statute in Ohio that says a judge may refer a foreclosure to mediation at any time, period. No rules on it, so once again, each of the 88 counties has their own rules on it. Not a defense to foreclosure, it's just, once again, time to sit down, discuss options, work on loss mitigation, try to reach a resolution. Doesn't happen as much as it used to. So then you get into, okay, what is that decree of foreclosure? It's usually prepared by the lender's attorney, because once again, we see them every day. We prepare these things every day. A proper decree of foreclosure recites the pleadings, who filed what answers, what parties have made an appearance, what is service complete. Finding that service was proper, obviously invoking the jurisdiction of the court. The non-answering parties have default judgment, finds the, who contested the foreclosure, finds the amount due on the note, usually supported by an affidavit of the lender, finding that the mortgage is a good and valid lien. If it's not a good and valid lien, finding that, we're going to reform the mortgage to make it a good and valid lien, fixing all the stuff, finding what conditions were broken, the borrower defaulted on the loan, finding the priority of liens, taxes first, court costs, taxes, first mortgage, second mortgage, the homeowner's equity at the end, all that stuff. The cancellation of the equity of redemption. We talked about redemption being the ability to stop the foreclosure from happening. There's multiple ways of doing it by common law, which is the equity of redemption. It's an odd part I'm not going to get into much. Statutory redemption I'll go at the end of the presentation. And then, of course, an order of sale and a distribution of proceeds. Does the court order that the property be sold and that the money be distributed? You'd be amazed at the attorneys who don't do this often who leave that part out. You're like, wait a minute, you had this money judgment that finds us of a default on the loan, but you didn't actually order the property to be sold. Consent judgments are things that I do often to resolve litigation. If somebody signs off on your judgment entry, you don't have to file a motion against them. They agreed to it. I do this all the time with defendants and homeowners. Like, I'll say, I will waive the personal judgment I'm entitled to. You agree to foreclosure. Basically, you move out of the house and I go my way, you go your way. Settles a whole lot of cases. It's a final and appealable judgment. There could be 5 liens against the property. Every lien holder can independently ask for foreclosure of their own lien, but you're only going to sell the property once. So usually in civil procedure, if you've got multiple claims and defenses that haven't all been resolved, it's not final or appealable. Well, in foreclosure it is. You put in a 54B certification, the one lien holder who actually proved their entitlement to foreclose gets to move forward, even if other lien holders are still suing the homeowner or jockeying for position or doing whatever. So once again, the goal is just somebody gets to. There's local rule requirements. Each county gets to say, this is the way I do foreclosures, this is the way you have to do it. I'm not going to get into the nuances of it, but obviously do whatever your judge tells you to do. And then we get to the actual sale part itself. This is actually the quickest part because this is the most mechanical part. A sheriff or a master commissioner represents a court's officer who conducts judicial foreclosures. Many states use private selling officers. Sometimes they're known as trustees in those non-judicial states. It's not a court officer, it's just whoever you hired as an auctioneer. Ohio actually now allows private selling officers in lieu of the sheriff. There's a confirmation process where the court reviews the sale and blesses it, and then of course the eviction at the tail end. So starting with ordering the sale. When you get a judgment in Ohio, ordering the sale is a remedy. So at the time of judgment, the court closes its file, the court's docket says closed and terminated, the litigation is over. Why? There's nothing more for the judge to do. It's up to you to decide how to execute on that judgment. I could garnish wages. I could take the personal property. I've got a money judgment normally. But normally I want to sell the property, so I file a separate, not action per se, but a remedy. I press feed to the sheriff to sell the property. Or now in Ohio I can file to designate a private auctioneer to do that for me. In Kentucky, they think that the only purpose of the foreclosure is to sell the property, so the final judgment in Kentucky contains the order of sale that immediately kicks it to the court's master commissioner to sell. They say, why break it up into 2 steps? If you're foreclosing, you'll want a sale at the end. So it's automatic. In both states, the court officers are going to appraise the property. This is, once again, a homeowner's defense. In Kentucky, you can buy property for $1, but there are certain rights that protect the homeowner from that. In Ohio, you can't buy the property for less than 2/3 of the appraised value. This ensures that the homeowner at least gets some value for their property, and it's just not sold at the sacrifice price of $300, at which they lose all the equity they could have. In Ohio, the appraisals were going kind of slow, so there's some rules now that if they don't do the appraisal, we're just going to use the tax appraised value. Just move on with life. Some people say, well, that tax appraised value is never accurate. Yeah, well, foreclosure appraisals aren't really accurate either. They're just a yardstick to give the homeowner some protections. It's not like they're using a full-blown, in-the-house appraiser that's taking into account the new cabinet you just put in. It's not that big of an appraisal process. One of the new things in Ohio is the private selling officer, the injection of these non-judicial remedies into this judicial process. A private selling officer is just a licensed Ohio auctioneer. They get their own part of the revised code. And one of the things they can do is they can conduct the auction online. Auction.com does a bunch of Ohio court-sponsored judicial foreclosure auctions now. They've got a private auctioneer who likes to use their website. You can go on to auction.com and bid on property. They like to brag that, one of the first people that bought Ohio property was a guy in England. Well, he happened to live in Ohio. He just happened to be on England for business and, bought the property down the street from him. So that's the wave of the future. In 5 years, all Ohio foreclosures will be online by statute. Now, the sheriff has to come up with their own online bidding platform to compete against the private folks. But in 5 years, there will be no sheriff on the courthouse steps crying foreclosures. In 5 years, by statute, it will be all on the internet. So, hey, real estate in Ohio finally jumped into the 21st century. Kentucky still kicks it old school. You're showing up at a master commissioner's auction in the hallway of the courthouse. But, you know, with auction.com, it's like using eBay or probably getting myself there, but any other auction site where, once again, you can bid up to 7 days before sale. The computer will save your auto bid, you know, all that stuff. And you can postpone a sale. Postponement is kind of a right to stop and start the foreclosure that doesn't usually occur when there's a foreclosing officer, a court officer doing that. I'm going to cover that a little bit later, but it's, you know, a new world out there. Advertisements, once again, is a civil notice kind of thing. You can't have a good sale unless people know about your public auction. The reason it's a public auction is we want to increase the amount of bids. If the homeowner owed a lot of money, we want them to owe as little as possible at the end. Or if they get equity at the end, if someone outbids the lender by $10,000, hey, that $10,000 goes to the homeowner. So as a protection, these public auctions get publicly advertised to drive up the amount of bidders that hopefully make the highest and best financial use out of this property. And there's rules on how you do it and where you do it. It's going to vary by state. Now, what I forgot to mention is this sale process is mirrored in those non-judicial states. Those non-judicial states skip the litigation part and go straight to the ordering the sale part. So in Georgia, in Texas, and California, they're posting notices in the paper. They're following rules on how they auction off the properties. There's always that stuff. So when it comes to then controlling the sale, postponement versus cancellation is the next big thing. In these non-judicial foreclosure states, when the lenders hire their own auctioneers, they call the shots. They tell the auctioneer to sell or not sell, pull the sale, wait 7 days for the sale, I'm not ready, let's wait 6 months. You know, back and forth, there's a lot of postponements. That's a temporary cessation of the sale. Sometimes you file a new notice in the paper that it's been postponed. Sometimes the guy just cries out on the courthouse steps, this sale is postponed for a week. If you're not there at the courthouse steps, you wouldn't have learned about it. With Ohio online, you post a notice on the website. Well, this has been postponed, come back in a week. Versus canceling the sale. Cancellation is shutting down the entire process and restarting the whole process. New appraisal, new advertisement in the paper, new sale date. In judicial sheriff and master commissioner foreclosures, there is no postponement. We have to tell our clients you cancel and restart. Well, Bill, it takes the sheriff 90 days to get back to sale. You're saying I got to get back in line and wait 90 days? Yeah. And the judge has to approve of canceling the sale. There are some judges who do not approve of canceling the sale. They hate when lenders stop and start foreclosures and they say, not in my courtroom. In fact, there is another judge in Cuyahoga County who, if you try to cancel a sale because the lender just didn't feel like it, she will order you to show cause to appeal why you should not be held up for in jail for even trying to cancel the sale. We have had multiple of our attorneys have to drive up and beg for ransom. Hate that, because we're just doing what our houses to do. But some judges get really mad about that. But that's the difference between postponement and cancellation. Conducting the sale, this is the actual McCracken County Master Commissioner, if you ever want to go down to a foreclosure auction. I've been to multiples of them. They're usually not exciting. It's the same people who show up every day to bid. Not much happens unless somebody forgets to bring their bidding instructions, at which point that's the person who's panicking and sweating as they're about to make a $300,000 mistake, and we scramble. So once again, we talked about opening bids. Opening bid in Ohio is 2/3. They'll take the appraisal and say, okay, I got an opening bid of X. Who's going to give me X? The bank's bidder is always at the sale, which is usually one of our employees or one of our vendors. So we're always opening the bid, and then we pray to God somebody else outbids us. Because once again, we don't want the property. We want someone to buy the property. The homeowner can bid at the sale. If the homeowner's got the money or got a line of credit or got a rich uncle, nothing's stopping the homeowner from buying back their property. So if the bank's owed 100, but the bank stops bidding at 73,000, the homeowner can go 74,000, and they say, okay, sold to the guy who actually owns the property for 74,000. And as long as the homeowner pays the 74,000, his mortgage is wiped away, because all you get from sale is all that somebody's willing to bid. There is no guarantee of an actual payoff from a foreclosure sale. The only thing you're guaranteed is that it will go to public auction. That's it. So at the end of that, there's going to be a return on the order of sale. This is the official record that happens. Sometimes in non-judicial states, these Returns on order of sale are recorded in the land records so that people know what happened at sale. That's the official return. And the judicial process, obviously, it's filed with the court so that the court knows what happened at the sale. Because remember, the judge closed their file at the time of judgment. The judge doesn't look at the sale process until the sale process is done. So the return of sale then allows the court to look at the confirmation of sale. Confirmation is that magic moment when the foreclosure finally ends. The Supreme Court of Ohio came out with some case law to remind folks that there's two major judgments in a foreclosure. The decree of foreclosure, that the homeowner still owns the house. It's not until the confirmation of sale that you actually complete the foreclosure and do what people expect. You expect that the sale was properly conducted. Obviously, the court has to make sure all the T's were crossed and I's were dotted. Vest equitable title in the purchaser. Hey, you, the bidder, now by power of the court own the house. The sheriff or master, whoever sold you the property, is going to prepare a deed to. That's your legal title. You don't hold actual record title until you get the deed, but that's after the confirmation. Once the confirmation happens, you're the owner. The rest of the world might not know it, but the court says you can start evictions, you can own the property, you should insure the property that it belongs to you. It terminates the mortgager's statutory right of redemption. That's big because, once again, if you're trying to move on with life, you have to make sure all those prior interests are extinguished. Orders for repayment of the bid. Repayment of the bid, obviously, it tells you where the money goes and to who. Identifies any deficiency judgment. Once again, if there's $20,000 left over that's still owed to the lender, the court can certify that. If there was a bankruptcy that terminated liability, if there was constructive service, if the lender waived the deficiency, at that point, there is no deficiency judgment. Whatever the lender gets in the confirmation process is all theirs. And then, of course, the big thing that I love, cancels all liens of record named in the foreclosure. If you are not named in the foreclosure, you're not under the jurisdiction of the court. If you're not under the jurisdiction of the court has no power to extinguish your interests. Now, if you got your interest post Liz Pendens, hey, well then you're on notice that you should have intervened into the case. But if your title examiner's title exams smell like wild turkey, I've had that before, we fired that guy, then obviously a missed lien becomes a problem because they show up and say, hey, I have an interest in the property. You never marshaled or foreclosed my interest. So the guy who just paid $150,000 for this property, well, he can pay me $15,000 or I'm going to foreclose my $15,000 second loan. Mechanics, judgment lien, you name it, whatever. That makes the guy who just spent $150,000 in foreclosure very angry, which is why there is a judicial title policy that's also issued in Ohio now that the lender has to pay for, just in case these missed liens exist. So that's something they added in 2007 to protect people who buy foreclosure sales. And after that, we're talking about the statutory right of redemption. Every state has a different right of redemption. In Kentucky, if you bid 2/3 of the value of the property, your redemption is gone. Poof, done. As long as you get 2/3 of the value of your property, you can't get your property back. You either should have paid off your lender before the sale occurred, or you should have outbid your lender at the sale. In Ohio, you have the right to pay the lender back until the court confirms the sale. Now, a lot of borrowers say, Bill, if I had $100,000 burning a hole in my pocket, I wouldn't have let it go to foreclosure. But that's Ohio's right. If you can come up with all the money, you can stop the foreclosure sale from being confirmed. Not a very powerful right of redemption. But once the court confirms the sale, you can't get your house back anymore. At that point, you're foreclosed. As I mentioned earlier, Michigan, you can redeem after the sale and after the deed goes to the lender. Each state's going to have different rules on redemption. Kentucky used to give you a year to redeem if redemption rights existed. They've now shortened that to 6 months to redeem. Once again, it's a creation of statute. They can monkey with the statutes whenever they like. So then you get to the deed, and it's usually prepared by the lender's counsel. The sheriff or the master or the private selling officer signs off on it. They record the deed. Some lenders used to hold their deeds for 6, 9, 12 months until they resold the property, and then they would record their deed from the foreclosure at the same time as the new deed to the new guy. And during that year-long period, the city had no idea who owned the property. who's in charge of these housing violations? Who gets the tax bills? So they've now created time limits on recording the deed. In Kentucky, you got 5 days. When the master commissioner gives you a deed, you go race to record it. In Ohio, they've decided that the sheriff's going to record the deed for you within 14 days, just so you can't screw that up. And then, of course, you get to the evictions part at the end. That's the part that people don't normally like, but it is normally the tail end of the foreclosure. If the court has jurisdiction over you already, the court can order you to leave the house. If you weren't named in the foreclosure, let's say you're a tenant or a renter who lived in halfway through the foreclosure, once again, your tenancy rights got extinguished. You got them post-live pendens. You didn't have a recorded tenancy in the land record. So you're thinking, oh, I don't want to get evicted. Well, somebody else owns your property now, and they don't have a contract or a lease with you. So you can file a forcible entry and detainer action and get evicted that way. Luckily, you don't owe rent to the new owner because the new owner doesn't have a lease with you. So for tenants, that's your only silver lining, is nobody can get rent money from you. And with that, the purpose is to sell the house, move on, hopefully have someone come in and make economic use of the property. So with that, I think I went 2 minutes over my timeline. Thank you all. I know I talked a lot. If you have any questions, say it.
Thank you, Bill. Here's the usual swag, but that can have a little special this time. Okay, so enjoy. Thank you for being here. Thanks, everybody.
2 years old now. Take the back.
No, you're good.
No, that's why they're in a special box. They have a special room that picks up the
Sure. Fire rating.
Yeah, later.
monetary penalty.
I don't remember.
Violation of extradition. Thank you. Yeah, they got me at 45.
I didn't know. I know. I'm like, after this meeting, I feel like so what do you say? He.